Hello, this is Dr. Mark Leiser. Welcome to my series of lectures on digital technology, law. My work sits at the intersection of law, digital technologies, digital governance, and fundamental rights. And I want to start by saying something that's going to irritate some people, but I think it needs saying plainly. Civil society, parts of the data protection community, and some regulators are treating the Digital Omnibus as if it was a deregulatory attack. The line you may have heard is familiar. Any attempt to clarify the meaning of personal data is a threat to rights. Any attempt to make Article 9 more administrable is industry capture. Any attempt to talk about enforcement is a neoliberal distraction. I think that's naive, and I do not say this word lightly at best. In some versions, it's even worse than naive. It's evasive. It doesn't recognize the myriad of issues and the complexity behind each of them that is maybe laboring our ability to regulate digital technologies. So the reason is simple. You can't have it every way. You can't insist on an ever-widening concept of personal data. You cannot then insist on every possible sensitive inference should be treated as special category data. And you cannot then acknowledge, and everyone does when they're being honest, that DPAs have finite staff, finite budgets, finite technical capacity, finite litigation capacity, and finite political room. And then you cannot insist that this produces stronger protection for fundamental rights in the real world. That's not a legal argument. That is you wrapping yourself in a comfort blanket of utopian hopes and dreams about the way the world of regulation works. Now, to be clear, this is not a lecture about weakening rights. It's not a lecture about giving industry cleaner escape routes or the ability to avoid regulation. It's not a lecture about pretending the GDPR has somehow become too demanding because compliance officers are tired. It's actually quite the opposite. My argument is that fundamental rights are not protected by maximal uncertainty in the trigger logic, the meaning of personal data. Rights need legal architecture. Rights need triggers. Rights need institutions that can enforce them. Rights need courts that can supervise them. Rights need people who can understand, at least to a reasonable degree, when the law applies and what follows on from it. This is why the omnibus matters more than many people think. It matters because the entry point of the GDPR matters. The meaning of personal data under Article 4.1 is not a decorative definition. It is the switch that activates the whole system. If that switch becomes so broad, so unstable, and so dependent on hypothetical future possibilities that nobody can say with confidence that it is pulled, when it is pulled, that the problem is not just practical inconvenience, it becomes a rule of law problem. And that's the human rights point. European human rights law has never treated legality as satisfied merely because a statute exists somewhere in the background. The law must be accessible, it must be foreseeable, it must constrain discretion. If the scope of a fundamental rights regime becomes impossible to locate, that is not automatically a badge of strong protection. It may be a sign that the law has lost the discipline needed to effectively protect fundamental rights. So my thesis is deliberately uncomfortable. The status quo is not neutral. Conceptual maximization of the meaning of personal data is not automatically rights protective. DPA under-enforcement is not a side issue. And the annoyance economy, the lived experience of cookie banners and refusal friction and dashboards and consent fatigue and compliance theater is not separate from the very legal architecture that the omnibus is seeking to address. It is partly produced by it. And that's what this lecture is about, and that's what I want to unpack. The first slide here captures what I call the false comfort. It's the basic problem. It's the impossible comfort at the heart of the civil society critique. The critique often proceeds as three things can be true at the same time. First, that the concept of personal data should keep expanding towards everything. Second, that enforcement resources will remain finite, fragmented, and under serious pressure. And third, that the result will nevertheless be stronger and more effective protection for fundamental rights. I do not think that triangle possibly holds. It sounds attractive because it allows everyone to occupy some morally comfortable position and lecture externally that this omnibus is weakening fundamental rights. Who wants to be against fundamental rights? Who wants to sound as though they are narrowing the GDPR? Who wants to be accused of doing industry's work? So the argument becomes simple. Broader is safer, narrower is more dangerous, and clarification of the meaning is suspect. Uncertainty is precautionary. But law doesn't work by moral atmosphere. Law works through concepts, thresholds, burdens, procedures, institutional capacity, enforcement choices. A legal regime can be broad in theory and weak in practice. A right can be formally available and practically exhausting. A scope rule can look protective on paper while producing delay, noise, defensive compliance, and user burden in the real world. This is why the DPA point matters. When I say that DPAs are not doing their job, I don't mean that every regulator is incompetent or that they're not excellent people inside these authorities. Of course they are. The point is institutional. Too many DPAs and too much commentary around them act as if the answer to under-enforcement is always more scope, more formal obligations, more jurisdictional reach, more theoretical coverage. But if a supervisory authority cannot effectively prioritize the cases already in front of it, widening that fog does not solve the problem. It gives the authority more things not to enforce. That isn't rights protection. It's rights rhetoric, something that some of the people working in civil society are really good at. But if you can move away from the sort of moral superiority approach to their arguments and actually look at facts, you can clearly say that this is a very superficial level of argument, and then when you go a little bit deeper, that you can see that this isn't rights protection. Civil society, unfortunately, for me, this is a very disappointing stance that some of them have taken. They should be the first to care about this. If the objective is meaningful protection against manipulation, surveillance, discrimination, exploitative ad tech, abusive profiling, children's data harms, and AI-mediated unfairness, then we need a regulatory system that can identify those risks and act on them. A system that treats every marginal identifiability puzzle as equally salient will not do that well. It will spread attention thinly. It will encourage symbolic enforcement. It will invite organizations to build compliance systems around the management of uncertainty rather than the reduction of harm. And that's the key distinction. Coverage is not protection. A legal system can cover more while protecting less. It can generate more notices, more policies, more dashboards, more records of processing, more cookie banners, more consent flows, more DPIAs, and still produce less meaningful agency for the people whose rights are supposedly being protected. So when I say the current line is naive, I mean that it ignores scarcity. It ignores incentives. It's ignoring how legal uncertainty is operationalized inside organizations. It ignores how users experience compliance. And it ignores the basic rule of law point that power, including regulatory power, needs intelligible limits. The question is not whether we want strong rights. We do, of course we do. The question is whether we're willing to build a legal architecture that makes those rights enforceable. This is where the annoyance economy comes in. I wrote a book on dark patterns, deceptive design in the law, and one of the phrases that is routinely thrown around in that sphere of people that talk about data protection, consumer protection, digital design, and the failures thereof is that we live inside what we call the attention economy. And the attention economy is about websites and apps being built to grab our attention, addictive design, for example. But I actually think increasingly that this phrase attention economy misdiagnoses what is actually happening. It is not wrong exactly, it just misses something important. It suggests that the central contest is for attention, for eyes, for clicks, for time, for engagement. But much of the digital environment is not merely designed to capture attention in any meaningful sense. It's designed to exhaust us. Like opting out is harder than opting in. Refusal takes more steps than acceptance. The reject button is hidden or softened. The accept button is bright, obvious, and immediate. Interfaces are layered with nudges, repetition, countdowns, vague warnings, guilt, friction, asymmetry. Users do not always choose because they are persuaded. They choose because they're tired. That's the annoyance economy. Systems monetizing friction, that asymmetry, and cumulative irritation. Now, this isn't just a design critique, it's also a legal critique. The law did not invent the cookie banner. I am so over civil society people and academics saying surveillance capitalism is the reason why we have all of these horrible cookie banners and whatnot. Like, the law didn't tell companies to turn refusal into an obstacle course. The law did not say that user interfaces should be built around performative choice, but legal uncertainty, fragmented enforcement, and poorly calibrated trigger logic help make some of those systems economically rational. How do you comply with the law unless you make steps which are particularly easy for users to give that indication that it's okay to process personal data? So think about the internal compliance conversation that's likely to happen at a company that's building a website or an app. Nobody wants to be the organization that under-notifies. Nobody wants to be accused of missing a consent obligation. Nobody wants to take a nuanced position on identifiability if the downside is enforcement risk and reputational damage. So the safer institutional response becomes show more notices, collect more consent, add more controls, build more preference centers, add more warnings, document more processes, and push more decisions onto users. The result is compliance theater. A banner can be shown, a box can be ticked, a choice can be offered, a privacy notice can be licked, a dashboard can be made available, and the legal system can then congratulate itself that information was provided and choice was respected. But the user was not empowered. The user was exhausted. That's the move that I want people to understand. The annoyance economy is not just the product of bad actors making bad design choices. It's also the product of a legal and regulatory environment in which ambiguity is converted into user burden. Where the law is unclear, organizations over-formalize in the visible layer while underprotecting in the substantive layer. They ask for consent where consent is not meaningful. They create choices that are not real choices. They use friction to manage legal risk. They turn regulatory uncertainty into design architecture. This is why the omnibus matters. Not because simplification is always good, not because industry should be spared obligations, not because the GDPR is too hard. It matters because the entry point matters. If we do not know with sufficient clarity when the GDPR is triggered, everything downstream becomes unstable. Rights, duties, enforcement priorities, compliance practices, and ultimately the lived experiences of users. And this is why the status quo is not neutral. A blurry trigger does not simply create broader protection. It creates incentives. Some of those incentives are ugly. Some of them show up on the screen as friction, fatigue, and annoyance. The user is not merely watched. The user is worn down. The next point is the most basic legal or doctrinal point, but it's also the one that gets lost most often. The GDPR does not regulate data in the abstract. It regulates the processing of personal data. This matters. The definition of personal data is not a minor interpretive detail. It is the whole jurisdictional switch. It's the point at which the law says this activity is sufficiently connected to an identified or identifiable person that the data protection architecture applies. Once that switch is flipped, a great deal follows. Lawful basis, fairness, transparency, purpose limitation, data minimization, storage limitation, what else? Security, accountability, rights of access, erasure, restriction, portability, and objection, data protection by design and default, DPIAs, potentially Article 9, potentially Article 22, potentially cross-border cooperation, potentially administrative fines, potentially collective redress. That architecture is important. It is often justified, but it's not costless. It consumes institutional capacity. It consumes compliance resources. It consumes user time. It also creates behavioral incentives inside organizations. That's the core mistake a conceptually maximalist approach to personal data comes with it. They assume that broader scope automatically means stronger rights. That's an attractive assumption. It sounds protective, and it sounds precautionary, and it sounds morally serious. Oh, well, let's make identified, let's broaden the scope of what amounts to identified data so we can bring more under the umbrella, so we'll have a broader scope. But that confuses coverage with protection. If everything is potentially personal data, then nothing can be prioritized effectively. If every data set is always in scope for every actor because someone somewhere with some other information might identify someone at some later point, then the GDPR becomes not a law of personal data, but a law of everything. That phrase is not just rhetoric, it captures a real problem. The broader the concept becomes, the more it risks absorbing the entire digital environment into data protection law. And the problem with a law of everything is not that it protects too much. The problem is that it protects badly. It protects duties thinly. It spreads regulators thinly. It spreads users thinly. It invites formalism. It incentivizes paperwork. It produces defensive compliance. It encourages organizations to bury users in notices, banners, preferences, dashboards, portals, and controls that are formally available but practically exhausting. That's not fundamental rights in action. That's a right-shaped noise, an illusion. The trigger question, therefore, cannot be treated as a technical side issue. It's the hinge of the entire system. If the trigger is coherent, obligations can scale in line with risk. If the trigger is incoherent, everything downstream becomes unstable. Enforcement becomes diffuse. Compliance becomes performative. Users are burdened with decisions that they cannot realistically understand. Regulators are left managing volume rather than actual harm. And here's the important part. A more disciplined trigger does not mean a weak trigger. It does not mean that only named individuals count. It does not mean that pseudonymized data escapes. It does not mean that singling out is ignored. It means that controllers can structure themselves. It doesn't mean that controllers can structure themselves out of the law. A disciplined trigger means that the law asks the right questions. For this actor, in this context, using these reasonably likely means, with these foreseeable recipients and incentives, is there a real connection to an identifiable person or a real capacity to single out and act upon that person? That is a much better question than asking whether identification is imaginable in the abstract, because almost everything is imaginable in the abstract. Law needs something more disciplined than imagination. Recital 26. This brings us to Recital 26. Recital 26 is too often invoked as if it was a slogan. It is not. It is a test. It tells us that identifiability must be assessed by taking account all of the means reasonably likely to be used, such as singling out by the controller or by another person to identify the natural person, directly or indirectly. It also tells us to consider objective factors, cost, time, available technology, and technological development. That language matters. It does not ask whether identification is metaphysically possible. It does not ask whether identification could be imagined by an academic, a security researcher, a hostile state, a data broker, or hypothetical adversary with unlimited resources. It asks whether means are reasonably likely to be used. That is a practical test, a contextual test, a relational test. The case law reflects this. Breyer is often cited for the proposition that dynamic IP addresses can be personal data. Yeah, that's true, but it's also very incomplete. The point in Breyer was contextual. The website operator did not hold the subscriber information directly, but there were legal means through which identifying information could be obtained from the internet service provider in relevant circumstances. The court did not say every identifier is automatically personal data for everyone in every context. It asked about the means and legal possibility in the real institutional setting. Scania reinforces the point. A vehicle identification number is not personal data in the abstract, floating free of context. It may become personal data when the relevant actor has reasonable means of linking the vehicle to an identifiable person. Again, the point is relational. The same information may have different legal status for different actors depending on their means, roles, and practical access to additional information. EDPS versus SRB litigation takes the same logic into synonymization. Synonymized information is not automatically personal data in every case for every person. The question is whether, for the relevant actor, re-identification is reasonably likely. That does not make synonymization magic. It does not mean that controllers could hide behind tokens while retaining practical power over people. It means that the analysis has to be actor-sensitive and evidence-based. It isn't deregulatory, it's disciplined. The anti-avoidance concern remains real. We should not allow controllers to slice systems into artificial entities, outsource identifying steps, hide behind processors, or structure corporate groups so that no single entity appears to hold the whole picture while the system as a whole retains power over persons. Means reasonably likely must include foreseeable access through processors, affiliates, contractual partners, ad tech intermediaries, data brokers, platform ecosystems, and onward transfers. It must include singling out. It must also include the ability to act upon a person even without knowing their civil name. But notice what follows on from that. The answer to avoidance is not conceptual maximalism. It is better drafting, better presumptions, better evidential burdens, and better enforcement. A legal test that can be abused is not a reason to abolish the test. It's a reason to design the test properly. If the law says reasonably likely, then we should take that seriously. If the law says objective factors matter, then we should use them. If the law says the controller or another person may have relevant means, then we should ask which other person, in which relationship, with which foreseeable access, and with which practical incentive. That is not a loophole, that's legal analysis. And this matters because fundamental rights need an object. Duties need a trigger. Enforcement needs a target. Recital 26 is not an inconvenience to be waved away by maximalist rhetoric. It's one of the GDPR's internal mechanisms for keeping the law broad without turning it into a law of everything. This is the context in which I think the omnibus should be understood. The interesting question is not whether one is for or against simplification. That's not a serious argument. That's not people that make these claims should be treated with a little bit of contempt, right? Be careful of people who make that distinction too quickly. Simplification that removes rights is deregulation. Simplification that removes pointless ambiguity can be rights enhancing. Simplification that narrows the law around the wrong line is dangerous. Simplification that clarifies when obligations genuinely apply may be necessary. The Commission's proposal tries to clarify the definition of personal data by making clearer that information is not necessarily personal data for every person or every entity, merely because another entity can identify the natural person. It also tries to emphasize that the assessment should take account of the means reasonably likely to be used by the relevant entity. Now, the EDPB and the EDPS have objected strongly. They have an interest, I think, in preserving the status quo. Their concern is not trivial. They worry that the amendment could narrow the concept of personal data, overlook singling out, encourage loopholes, and create more uncertainty rather than less. These concerns should be taken seriously. A badly drafted clarification can become a badly drafted escape route. If the phrase "for that entity" is read too narrowly, the law may invite precisely the formal fragmentation that data protection law should resist. A controller could attempt to divide knowledge across affiliates, processors, ad tech partners, brokers, or contractual recipients, and then claim no one entity sees enough of the picture. That would not be clarification, that would be avoidance by architecture. But that doesn't mean clarification is wrong. It means clarification has to be drafted against avoidance. This is where the debate is being framed very badly. The line is not broad rights versus weak rights. It's not industry versus regulators. It's not data protection versus innovation. It's whether the trigger can capture real power over persons without collapsing into theoretical possibility. A defensible omnibus position would have guardrails. It would preserve singling out. It would include practical capacity to act upon persons. It would treat foreseeable recipients seriously. It would prevent artificial fragmentation across corporate groups, processors, brokers, and platform ecosystems. It would require accountability from actors who claim that data is outside scope. And it would make clear that reasonably likely does not mean not impossible. That's the position I think serious lawyers should be working toward. Civil society is right to worry about loopholes, but it is wrong if it treats the current uncertainty as if it was itself a form of protection. It's not. Uncertainty can be exploited by industry. It can be converted into compliance theater. It can be used by regulators to avoid prioritization. It can be passed on to users in the form of friction and fatigue. So if the omnibus text is flawed, fix the text, tighten it, add anti-avoidance language, add evidential burdens, clarify recipient logic, preserve singling out, make the test harder to game. But don't pretend that the status quo is constitutionally or operationally ideal merely because it feels broader. Breadth without discipline is not protection. Sometimes it's just fog. And fog benefits repeat players. It benefits the powerful. It benefits those who can hire lawyers, build systems, absorb uncertainty, and pass costs on to users. A rights-respecting system should not be built on fog. Now, the Article 9 problem is the same problem in sharper form. Special category data is not a decorative label. It's a heightened legal category because some processing creates particular risks: discrimination, stigma, exclusion, manipulation, chilling effects, intimate exposure, and unequal treatment. That is why Article 9 exists. It's supposed to mark a special kind of vulnerability. And the Court of Justice is right to resist crude formalism here. In OT, the court recognized that data can indirectly reveal sexual orientation. In Meta, the court recognized that the collection and combination of data relating to visits to websites or apps may reveal special category information. These cases matter. They prevent an absurd situation in which a controller avoids Article 9 by never asking the sensitive question directly while building the same profile indirectly. If a platform uses browsing patterns to infer depression and then targets people with products, ads, prices, or content on that basis, Article 9 should bite. If an employer uses behavioral analytics to infer pregnancy, disability, mental health status, or trade union sympathy, Article 9 should bite. If an ad system clusters people by proxy characteristics that functionally stand for ethnicity or religion, the legal analysis cannot stop at the absence of an explicit label. But it's a different preposition has crept into the debate here. It says that any data from which a special category characteristic could be inferred is special category instance data in every instance for every actor, regardless of purpose, context, probability, use, or consequence. That's the folly. It collapses the category. Location data may reveal religion. Purchase data may reveal health. Browsing data may reveal sexuality. Reading habits may reveal politics. Exercise patterns may reveal disability. Social graphs may reveal almost everything. All of that can be true, but it cannot follow that every such dataset is always Article 9 data for every actor in every context. If it did, Article 9 would stop being a special regime. It would become a second law of everything. That would not strengthen Article 9. It would dissolve it. We need to keep 4 situations distinct. First, there is a direct special category data, a medical record, a trade union membership list, a declared religious belief, genetic data, biometric data processed for unique identification. Article 9 applies. Second, there is a deliberate inference. The controller uses ordinary data to infer health, sexuality, politics, religion, ethnicity, or another protected characteristic, and then uses that inference. Article 9 should apply. The risk is not reduced because the sensitive attribute was inferred rather than stated. Third, there is a strong contextual revelation. Data whose meaning, in context, is so closely connected to a protected characteristic that processing it reveals that characteristic in substance. Article 9 may apply even without a declared intention to build a sensitive profile. And fourth, there is a merely theoretical inference, data from which, in some speculative or low probability sense, a sensitive attribute might be inferred from someone using some model for some purpose. Treating all of that as Article 9 data in every instance does not enhance protection. It destroys the usefulness of the category. The right question is not, therefore, could someone infer something sensitive in the abstract? The right question is, does this processing seek to reveal, rely upon, or use a sensitive characteristic in a meaningful and reasonably foreseeable way? That is not under protection, it's boundary discipline. And without boundary discipline, the system becomes unmanageable. Controllers respond with more notices, more consent requests, more defensive classifications, more preference centers, more friction. Regulators are asked to police everything. Users are asked to make more decisions that they cannot possibly understand. The result is not stronger protection. It is the annoyance economy with a legal citation. This is the slide where I want to be blunt. Finite enforcement is not a neoliberal talking point. It's not industry propaganda. It's not a distractions from rights. It's reality. The supervisory authorities have finite budgets, finite staff, finite technical expertise, finite litigation capacity, and finite political room. They receive large numbers of complaints. Cross-border cases can be slow. Technical systems are complex. Large platforms are well-resourced. AI and ad tech systems are opaque. And many of the most serious harms are difficult to detect, difficult to evidence, and difficult to remedy. But I see this constant argument from some people in civil society. We need more enforcement. We need more enforcement. Like there's a magical enforcement budget somewhere where people can just throw time, money, and resources at enforcement. If that's the institutional reality, then a legal theory that assumes everything can be treated equally in scope and equally enforceable is just a fantasy. A system that treats everything as equally salient does not eliminate scarcity. It hides scarcity. It pushes scarcity into delay, inconsistency, non-enforcement, symbolic enforcement, procedural exhaustion, selective attention. Some cases are pursued because they are visible, politically attractive, or easy. Others are neglected because they're complex, cross-border, technically demanding, or resource intensive. The public sees activity, but not necessarily impact. The regulator experiences this as backlog. The controller experiences it as an ambiguity. The user experiences it as a friction. The bad actor experiences it as an opportunity. This is where I think part of the DPA community needs to be more honest. It's not enough to say that everything matters equally. That's not an enforcement strategy. It's not enough to say that the concept of personal data must remain as broad as possible. That does not tell us what to prioritize. It is not enough to issue guidance that expands obligations while complaint handling systems become slower and slower. If regulators want to defend fundamental rights, they need to defend prioritization, not just jurisdiction. And civil society should demand that too. The worst actors in the digital economy are not afraid of abstract maximalism. They are afraid of targeted, technically competent, well-prioritized, well-funded enforcement that understands their systems and can impose real consequences. If the legal system spends too much time chasing marginal formalistic cases, the more serious structural harms become harder to reach. This is not an argument for ignoring small harms. Small harms can matter. Repetition matters. Cumulative irritation matters. Low-level frictions can be part of a wider architecture of manipulation. But enforcement still needs triage. It needs a sense of material risk, systemic harm, vulnerability, scale, opacity, institutional power. Better trigger logic helps with that. It allows regulators to focus on processing that actually creates risk to people. Manipulation, discrimination, exclusion, identity exposure, chilling effects, intrusive profiling, children's data, exploitative ad tech, abusive AI systems, biometric surveillance, and genuinely unfair design. The alternative is a system that produces more of everything except protection, the very thing you claim you want. More banners, more dashboards, more notices, more formal choices, more defensive documentation, more legal uncertainty, more noise, more of the things you claim you don't want. Rights are not enhanced by maximal uncertainty. They are enhanced by a system in which people can understand when rights apply, controllers can understand what duties follow, and regulators can direct enforcement to where it matters. Scarcity does not make rights less important. Scarcity makes legal architecture more important. This is where the argument becomes a human rights argument. Foreseeability is sometimes treated as a lawyer's tidiness requirement. It's not true. That's unfortunate. It's one of the way European human rights law prevents legal power from becoming arbitrary. Under the Convention, interferences with qualified rights must be in accordance with the law or prescribed by law. Under the Charter, limitations must be provided by the law. These phrases do not merely ask whether a legal instrument exists somewhere in the background. They ask whether the law has quality. Can it be found? Can it be understood? Can it guide conduct? Does it constrain discretion? Does it tell people, institutions, regulators, and courts enough about where legal power begins and how it may be exercised? The classic Strasbourg formulation in Sunday Times case is still the starting point. A norm cannot count as law unless it's adequately accessible and formulated with sufficient precision to allow a person, with advice if necessary, to foresee the consequences of a given action to a degree that is reasonable in the circumstances. That does not mean perfect certainty. The court is not naive. It accepts open-textured concepts. It accepts legal development. It accepts that expert advice may be needed. But it does not accept legal consequences being left to institutional mood or retrospective reconstruction. The surveillance cases sharpen the point. In Malone, Crusling, Hubig, and latter cases, the issue was not simply that privacy was interfered with. It was that the law failed to indicate with reasonable clarity the scope and manner of the discretion conferred on public authorities. In secret surveillance, foreseeability cannot mean that a person can predict the exact moment that they will be watched. So the court asks a different question. Is the law clear enough about the circumstances in which power may be used, who may authorize it, how long it may last, how information may be examined, stored, shared, and destroyed, and what safeguards exist against abuse? The data cases make the point even clearer. In Recital, the intelligence service held and used personal information under a legal framework that did not adequately define the categories of information, person, circumstances, or procedures. In Oman, the creation and storage of a security file raised the same quality of law issue. In S and Marper, the retention of fingerprints, cellular samples, and DNA profiles required clear safeguards. In Glucan, facial recognition again shows why vague and widely formulated powers over biometric data are constitutionally dangerous. Luxembourg has reached a similar result through the Charter, Digital Rights Ireland, Teletus Verige, Opinion 115, La Quadrature du Net, and Schrems 2 all reflect the idea that serious interferences with Articles 7 and 8 require clear and precise rules and minimum safeguards. Now, I'm not saying that every ambiguity in the GDPR is automatically a human rights violation. That would be too blunt. Data protection law needs broad concepts. It needs technologically neutral language. It needs flexibility. The concept of personal data should remain broad. It must capture indirect identification, singling out, synonymous identifiers, relational data sets, and practical power over persons. But the argument is more careful than that. When the trigger for a fundamental rights regime becomes so indeterminate that individuals, controllers, regulators, and courts cannot reasonably foresee when it applies, the law has a quality of law problem. If personal data means anything that could possibly be linked to someone by someone somewhere with some other information at some future point, then the trigger no longer guides conduct. It becomes retrospective characterization. If Article 9 applies whenever any sensitive inference is imaginable, then the special category trigger no longer structures risk. It becomes a universal uncertainty machine. This is why Recital 26 is not just a technicality in the GDPR. It's a foreseeability device. Means reasonably likely, gives the law an internal discipline. It asks about practical, legal, economic, organizational, and relational means. It resists both evasion and fantasy. Foreseeability is therefore not the enemy of rights. It is one of the conditions of rights. Without it, power becomes harder to constrain, enforcement becomes harder to prioritize, and users become easier to burden. So what should a better omnibus position look like? Well, first, I think it should resist two temptations. The first is industry minimalism. That is the idea that contextual identifiability should become a convenient route out of the GDPR whenever data has been pseudonymized, shared, tokenized, or processed through intermediaries. That would be wrong. The GDPR must continue to capture effective power over persons. It must capture singling out. It must capture profiling. It must capture practical capacity to act upon individuals or groups in ways that affect them. It must capture systems where the civil name is absent, but the person is still targeted, ranked, priced, excluded, manipulated, or exposed. The second temptation is rights maximalism. That is the idea that any narrowing, clarification, or contextualization of the trigger is necessarily a weakening of rights. That is also wrong. A regime that cannot distinguish genuine identifiability from theoretical possibility does not become more protective. It becomes less enforceable. The rights position is constitutional, risk-based, and operational. First, the concept of personal data should remain broad, technologically neutral, and anti-circumvention. No serious person should want a return to the world where only names, addresses, and obvious identifiers count. Modern data systems operate through persistent identifiers, profilers, cohorts, device IDs, account IDs, tokens, and behavioral patterns. The law must capture that. Second, identifiability should be assessed contextually by reference to means reasonably likely to be used. That means technical means, legal means, economic means, organizational means. contractual means, and relational means. It also means foreseeable access to additional information through processors, affiliates, recipients, data brokers, platform ecosystems, or onward transfers. Third, reasonably likely should not mean theoretically possible. The GDPR should not be triggered for a particular actor merely because an identification pathway can be imagined by an academic, a security researcher, a hostile actor, or a data broker in a different context with different information and different incentives. Fourth, any actor claiming that information is outside scope should bear a meaningful accountability burden. They should be able to explain the factual, technical, legal, and organizational basis for that claim. They should have to revisit the claim when the context changes. Fifth, onward transfers should be treated seriously. Data that is not personal for one actor may become personal for a recipient, where transfer to a recipient with identifying means is reasonably foreseeable, built into the arrangement, are part of the commercial logic. The original actor should not be allowed to pretend that the recipient does not exist. 6. Special category inferences should be clarified without collapsing Article 9. The law should capture deliberate inference, strong contextual revelation, and sensitive use. It should not convert every data set into special category data merely because some sensitive inference is imaginable. 7th, enforcement priority should be explicit. Regulators should be empowered and expected to focus on processing that creates material risk to people, rather than allowing the system to be consumed by low-value noise. 8th, user burden should be treated as a regulatory harm. If legal uncertainty predictably results in more banners, more repeat consent flows, more manipulative preference design, and more refusal friction, that is not a neutral compliance cost. It is part of the harm the system should be trying to reduce. Put differently, the omnibus should not be defended as deregulation. It should be defended, if it is to be defended at all, as constitutional housekeeping. The aim should be to make the GDPR's trigger more foreseeable, more enforceable, and more resistant to both avoidance and overreach. That's not a softer position, it's a more serious one. So the final point is that maintaining the status quo is not neutral. The visual here in my slide hopefully shows you the loop. Foggy trigger logic feeds diffuse enforcement. Diffuse enforcement feeds performative compliance. Performative compliance feeds user exhaustion. User exhaustion then becomes part of the environment that allows the legal and commercial architecture to continue. That is the annoyance economy in legal form. Legal uncertainty helps make this possible. Where the law is unclear, organizations over-notify in some places and under-protect in others. They ask users to consent, where consent is not meaningful. They present choices that are not really choices. They use interface friction to manage legal risk. They turn regulatory ambiguity into user burden. This is the paradox. A maximalist theory of scope could produce a minimalist experience of rights. Everything is covered, so everything becomes formalized. Everything is formalized, so everything becomes a notice. Everything becomes a notice, so the user stops reading. The legal system that congratulates itself that information was provided and choice was offered. But the user was not empowered. The user was exhausted. The user was annoyed. That is why the trigger logic matters. It's why Recital 26 matters. It's why Article 9 inference logic matters. It's why enforcement resources matters. It's why foreseeability matters. And it's why the omnibus matters. A better defined concept of personal data, anchored properly in the means reasonably likely test, does something important. It stabilizes the regulation scope. It allows obligations to scale in line with risk. It helps regulators focus on processing that actually creates harm. It reduces incentives to rely on manipulative interface design as a compliance strategy. It reduces the everyday burdens placed on users. It doesn't fix everything. The annoyance economy is not caused by one definition. If the product of design choices, business models, enforcement scarcity, platform power, dark patterns, and legal uncertainty. We should not pretend that amending the concept of personal data will solve all of that. And my claim is not that it's going to do that. It will not. But we should also stop pretending that conceptual maximalism is the same thing as effective protection. It is not either. Thank you.